Hello, folks. Yeah, today will be an interesting day in the Uvalde school shooting officer trial. Mr. Rodriguez is charged with 29 counts of abandonment and endangering children. The charge is based on what happened from when he got there until the shooter went into the school. The state alleges that he had an obligation to act, and he didn't. He violated procedure, he violated his training, and that they claim goes to a criminal level. We left off yesterday with a Brady violation, or an alleged Brady violation. And we're going to take a look at, we're going to recap. I'm going to comment on it so we get up to speed until we get to, let's see, I'm going to show that. I'm going to put there. So just a recap with my commentary. Hi, by the way, Nick here. I am a jurist. I have a law degree, not an American one, but I do believe, I believe it gets me to the point where I have more than average knowledge about the justice system, but we both, you and me, learn as we go along. All right, time for recap while we wait for the hearing to start today.
Okay, we ready to bring them in?
Judge, actually, I do have just a few things I want to clarify on the record before they come in.
Okay.
Ms. Hale, you would agree with me in listening to the totality of your interview 4 days after that you never tell the ranger that you saw anybody that was dressed in black with long hair and a fire and a gun?
Correct.
You agree that you never told him that you saw dirt flying up on the playground? That was to you, I guess, putting two and two together, you felt like you were being shot at, which was your opinion.
Correct.
You never told the ranger any of those things.
I'm listening to that now.
Right. And that was 4 days after it happened.
Correct.
And you would agree he gave you every opportunity to say everything that you remembered about what happened.
Yes.
And seeing the shooter and seeing somebody with a gun on your school would have been something that you would have told him at the time.
I would think so, yes.
In the dirt and you connecting that to their bullets being fired in your direction.
Yes.
Okay. So the question I have is, when you talked to the prosecutor on those incidents, did you tell them those details about seeing the person in black and with long black hair or with long hair and a firearm? And did you tell them about seeing dirt being kicked up at the playground?
I believe so, yes.
All right, Your Honor. And so based on that, we have never gotten any notice from the prosecution. And that is clearly an inconsistent statement with the statement that she gave. The prosecution has never provided us. This is clear under Brady. It's clear under Michael Morton that if this is the first time that I'm hearing of this in a trial of this magnitude is when she testified on the stand about it. And so if she did report these things to the prosecution, we were entitled to that to prepare for this. And this is a trial by ambush.
Good. Yeah. Something I learned since yesterday, you heard him referencing Brady. You also heard him referencing Morton. Morton is Texas law. Michael Morton, this goes back to the, I believe it goes back 40 years. Michael Morton was charged, convicted, sentenced, and for the murder of his wife. Then, later, it was revealed that the prosecution in that case did not disclose to the defense that their child told in an interview that daddy wasn't home and the monster killed mommy. Never disclosed. That and other things. Which means that Texas has actually not only a Brady, as in case law, they actually have law that says if the prosecution, it doesn't have to be exculpatory, it has to be material to the defense, which includes trial strategy. So now that I did not know that until yesterday. So yeah, under those conditions, that she changed her story, added on to her story, told the prosecution, and the prosecution didn't disclose it. Yeah, that gets us into a whole new ballpark. But I have to say, I've been covering Texas cases before, and I can't say that every judge follow this to teeth, but it seems like this judge does. This judge follows the actual law. Remedies are the same as in Brady. Everything from jury instruction all the way up to mistrial with prejudice. Here comes the hard part. It is up to the defense to choose. If they go hard and ask for dismissal with prejudice, they might end up with nothing. If they go too low on the scale, with let's just have a jury instruction, well, you can't put the toothpaste back into the tube. You can't shovel the shit back into the horse. You cannot unfuck a clusterfuck. So it's up to the defense what they are aiming for. And the judge, of course. But let's keep listening here to what happened yesterday.
Response?
We're checking to see if it is indeed part of the grand jury testimony that was turned over to him.
Okay.
What? Yes. It's provided in the transcript that we provided to them on what's 134.
Remember here, as an officer of the court, she is here representing to the judge. We handed all of that over.
Here's the part which talks about the extension cord.
I agree that she said that before. I do see in the grand jury, the grand jury transcript, there was talk about dirt flying up around the kids. I do not see where she described seeing a shooter, seeing a person with a gun matching the description of shooter. And apparently she told the prosecution that before trial. I mean, Judge, that's an incredibly important detail that I'm finding out about now in front of the jury.
Yeah. And I like to add this. The prosecution had knowledge, at least one of the prosecutors had knowledge, the female prosecutor. I'm not so sure the entire prosecution team knew this. And nobody reacted. Not a single one of them. Oh yeah, about the boob cam yesterday. That now the camera guys are probably told were told some witnesses do not show their face. And I can't for my life understand the choice of having the camera at chest level. Now, there was another witness yesterday, a male, the funeral homeowner. Not that important, but Jesus Christ, Cranmer crew, you had an hour boob shot of an Uvalde teacher, and none in the production company thought of, hey, this might be inappropriate.
And how's that Brady or exculpatory, Your Honor?
Well, it's like insanely different. What I want to say is it is 180 degrees different than her prior testimony to the grand jury and her prior statement to the ranger. And it is of a matter of such importance because it has placed the gunman on the south side at the same place where my client was, where he responded to and where he went to. And so if this witness has told, and I understand witnesses testify, they remember things differently, but when the prosecution hears something that the witnesses remember differently than anything that we have, it's their obligation to provide that to us, because that would be what could be used for impeachment.
When we provided with the grand jury testimony that had about the dirt, whether or not it was a man in black, they've already stipulated that there's a man in black that was there.
I agree, but not at that location at that time. And this is a man dressed all in black, not just all in black, with long hair and a firearm and a gun.
Like there was more than one man in black and a gun.
But that's
south end of Rondo Country.
The prosecution, I'm sure, is not trying to intentionally miss the point, which I'm sure that the court understands my point, which is
that is lawyer speak for Judge. He's trying to gaslight you.
It's not about who did the shooting. Of course, we all agree with that. But at what time, when and where and how, and what teachers had identified a shooter or had seen a shooter on campus?
Well, the location is pretty important, Mr. Turner. Do we have anything that you show in your notes? You turn that over to them?
About the man in black.
Listen to the judge's question again.
Well, the location is pretty important, Mr. Turner. Do we have anything that you show in your notes? You turn that over to them?
About the man in black. No, Your Honor, I don't.
Specifically the location at that particular time?
Well, I guess the idea is the witness has testified that she told the state. Does the state acknowledge to the court that they were told that?
I said, I believe so. Sorry.
What?
Yeah. I mean,
Well, yeah, this witness should have been sent out during this. This witness should have been sent out during this. Now she heard the discussion. And it should not happen. It's bad when it happens, but sometimes witnesses wants to help. But it's also the prosecution's absolute responsibility to say, only testify to what you actually saw and heard and witnessed. Don't embellish, don't add on, don't take away. Just tell the court what happened. And now this woman, who she has my absolute sympathy. For me, she did not do anything wrong here. She should have been stopped by the prosecution. They should have, when they found out that all of a sudden her story changed, they should have had, Miss, this wasn't said in grand jury or in this video. Are you sure this is what you saw? And stuff like that. Because this teacher is a victim as well of the Uvalde shooting. Of course she wants to help. But the court should have sent her out, because now she hears, oh, things got screwed up. And she tries to help again, maybe, allegedly.
You know, the thing about it is that this woman was initially interviewed, you know, in a very traumatic event. So there's going to be things that she remembers, you know, for as time goes on. But
Listen to the gaslight. Listen to the gaslighting. Now, this is from yesterday. Again, for you who just joined, we are waiting for the hearing to start today, which will be a Brady-violation hearing. It might be other motions as well, but I think the center point is this Brady.
I agree with Mr. Turner. That's not exculpatory. You know, we all knew there. I mean, when saying to them, "Hey, there's a shooter, all black with a long rifle," is not information that they didn't already have throughout.
Listen to the gaslighting. First of all, every lawyer in that room knows that Brady is not exclusively about exculpatory evidence. It is of material importance as well.
Case.
In opening statement, they said that Melody Flores said the man that was in all black, but she got the gun wrong. So this is
I think his
new
complaint
information.
is more
that's
to the
Flores.
location of the man in black in relationship to where his client was.
I don't think she said anything about where his client was, first of all.
She put it,
Second of all, I think the testimony will be that Melody Flores saw him in the same spot that this woman has said it was. There's no new testimony there. There's no new evidence. There's nothing different than what they already know.
She never told us that the specific location that she saw him, about that south end of the door. She never told us that.
Okay. So what are you asking for?
well, can I have a moment?
Pretty quick, yeah.
Yeah, just need a little bit to talk to them.
Yeah.
I got a question. Who is the judge in this case? This is Judge Sid Hall, who is presiding over this. Let's skip ahead until...
Finish the record, so go ahead. Before they ask for their remedy, we'll go ahead and ask your question.
As far as the conversation you had with the prosecutors and the man in black, did you discuss, or do you have a firm memory that you discussed where he was, or did you simply discuss him and you saw the man in black?
And this is why they should have sent her out during the discussion, because now all of a sudden they ask her questions. And she becomes very vague.
I don't remember. Are you talking like during the grand jury? During the grand jury or when?
No, when you talked to the prosecutors in preparation for trial.
Oh, I don't remember now.
You don't remember?
If I discuss the location now.
Yeah. And I'd also like to ask Miss Mitchell, do you have any notes that we're discussing where?
I guess we're gonna take testimony. I'll tell you what, man, let's do this. I don't want you going back up to the fourth floor. Could you go with one of our bailiffs and just step out in the hall momentarily, and we'll bring you right back in? Don't talk to anybody about the case if you do me
No.
that favor.
If you think this was a clusterfuck before, oh, wait. First of all, it is extremely uncommon for a prosecutor to testify in the middle of a trial about something that happened. And usually, since she is already an officer of the court, she doesn't need to swear an oath.
Solemnly swear the evidence.
But here,
All right, Ms. Mitchell, you'd raise your right hand. You solemnly swear the
He
evidence in the
swears
testimony given in
her
the
in.
cause will be the truth, self you got.
Yes.
Mr.
it is at this point she knew she fucked up, or should have known.
Turner, we can just do it from council table if nobody objects. Go ahead.
Thank you. Were you there and conducted an interview with Stephanie Hill?
Yes, the trial preparation.
And did you take notes as a part of that?
Yes.
Do you have any notes as to Ms. Hale telling the prosecution where
Hold on here. People are gathering in the courtroom, but the defense is not there yet. Okay.
the man in black was?
No, she told us there was a man in, well, she looked, she saw a man in black with a long rifle. But she didn't tell us that he was specifically at that location at the south end on the sidewalk. She did say.
Thank you. And I'd also call Mr. Garza, Your Honor. Oh, I'm sorry, pass the witness.
Yep, but
Yeah. Cross-examination. Now, you would imagine in this serious matter, don't get feisty.
clarify for me, what was in the grand jury testimony that you did disclose?
That there was dirt flying up.
Okay, all right.
Yeah.
Question?
Ms. Mitchell, the notes that you're referring to, on what date was that interview done?
I have to go back to my calendar. It was sometime in mid-December.
Of
It was right before Christmas.
2025?
Yes.
Were you the only prosecutor present at that interview?
No, it was me, Mr. Garza, and Mr. Turner.
All right. And you were conducting the interview?
No, Mr. Turner was.
And in that interview, the witness that we're referring to told you she saw a man dressed in black with long hair and a long rifle.
Right.
All right. And you noted that she had never said that before at the time that she said that.
I didn't note that.
Well,
We're prepping her, so I can't say that I specifically noted that.
but I mean, you in just the preparation, you would have noted that a fact like that an additional person seeing the shooter at the time before the shooter entered the building outside, you would have noted that as a significant fact. You would agree with that?
She knows she screwed up. But here we go.
I would say that he was seen by several people, so
That was not the question. Seriously, miss, that wasn't the question. It doesn't matter if he was seen by other people. She never said that before. All of a sudden, she says it.
one other witness saying they saw him, such as Ms. Flores or, is part of that.
All right, but I guess what I'm saying is that whether or not he was seen, you understand and know that not only is location important, but time is important. Where the shooter is at a certain time you note that that is an important detail. Or
That is an
material.
important detail, but I wouldn't say that I was, at the time, had dissected the time frame with her to the point that it was so significant that it stood out to me.
Well, I guess that you'd also understand that different witnesses at different points in time, viewing a shooter in different locations, all of those things are important details as to know not just where the person was, but when in time the person was. And different witnesses will provide different times, right?
Right.
You understand that as a concept.
Right, I understand that.
And I'm not talking down to you, I'm just trying to make sure that, I know you understand it. I just want to make sure that it's clear on the record. And so, because this focus on whether or not she talked about the location, if that's the first time.
Just checking in on, yeah, judge is there, but hearing hasn't started. I'm just checking in from time to time.
So
we don't
that she ever said
any of that
location,
hearing.
and it just happened to be the location in trial that is where our client was. And now she's put the shooter on the south side of the building on the sidewalk, looking like he's going into the building on the south side in trial today. Are you saying she never said that to you before? In your notes?
Okay, were you asking me two different questions, like seeing him there versus seeing him specifically on the sidewalk? The term "the sidewalk" today caught me off guard because I had never heard that before.
So acknowledge, not only did she say new things to you, she said additional new things on the stand. And you didn't react thinking, oh crap. You just let it move on. You have an obligation to the court, miss.
Had you ever heard her say that she had seen him either going into the south side of the building or approaching the south door?
No,
Did she ever tell you that he was on the south side of the building?
no,
So nothing in your notes. Now,
no.
okay, so here's my question. At a time when you're talking to a witness and for the first time they're telling you that they saw the shooter, neither prosecutor or anyone in the room thought to ask her, where did you see the shooter? That wasn't a question that came up in anybody's mind to ask her where the shooter was?
You know, you're getting very nitpicky. Let me tell you something. When we were
That's the wrong fucking answer, miss. You playing offended. That miss or Mrs., I don't care. This is a courtroom. This is a trial. You are sworn in as a witness. That is highly, highly improper.
You know, you're getting very nitpicky. Let me tell you something. When we were prepping these witnesses, I was running a law office, and so I was in
So you were busy with other things on your mind?
and out of interviews, so I can't say that she said that and I like, oh my God. You know, it wasn't that type of reaction for me, so that's the best I can say.
I guess I know, but as a person present in the interview, I mean, this is who.
But I can say it's today when she said that.
All right, defense is gathering in the courtroom.
He was on the south end, I was surprised.
Just a few more
That's what I can
minutes.
say.
And we were too, or that she saw him at all. But you were not surprised, though, when she testified that she had seen him.
No, because she said that she had seen him. She said that during trial prep.
And so,
what she had seen is a guy with long hair with a gun.
And so you understand, with all the information that you provided us, and that your office provided us in discovery, you understand how we would be surprised that she testified that she saw him.
No, because I would assume that.
That pause is her scrambling for an answer.
Y'all knew that, given everything, given all the information that's been provided to y'all, that y'all would know that he's, the testimony, the evidence is that he's on that south.
She is blaming the defense that they weren't psychics. You should have known that she was going to testify about something she's never testified to before. She's blaming the defense for her doing a bad job. And you heard the tone of her voice? She's going with y'all. That is her losing her composure. Because she's unable, she knows she fucked up. She just can't admit it.
End of that building shooting into room 102, right?
All right. It seems like we are headed into today's hearing. All right. Sound. Yep, here we go.
I'm handing you Defendant's Exhibit A. I did not file it because with the filing system and
Okay.
subsequent strategy, that's what you asked for. I would just ask, I know
It'll
you'll
be
have to
sealed.
file it, but you asked that it be sealed after you.
Yeah, it'll be sealed.
Thank you.
And you had your notes, Ms. Mitchell?
The record reflects that I'm tendering to the court my notes, all of my notes. To the court, my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the street.
This will be
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th. At that time, I had not reviewed her testimony to the Rangers. It wasn't until the week of Christmas, I think all around December 26th, is when I started pulling the witness interviews with the Rangers that I reviewed for actual testimony to the Rangers. So the position that I should have had an epiphany on December the 10th when we interviewed her in anticipation of trial is misplaced. And I just wanted to make sure that that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th when she reviewed it.
seriously, Miss Prosecutor, you didn't review the information she gave the Ranger before you prepped her? It's good that you acknowledged that to the court, but that kind of makes things worse. That tells me that she was ill prepared for the trial prep with the witness. So she could not really say to the court or testify to the court yesterday that she had reviewed what should have been reviewed.
Okay.
Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will, obviously at this point, take any motions or arguments as far as remedies
For proceedings in this matter, so defense?
Yes, Your Honor. So as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
Well, let me just say this, under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there's a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst. So I do have the remedies under Heath available, but, if you're making your motion for mistrial, I will tell you, I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and frankly, I think that was kind of a very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that would either corroborate or override what she said. I believe the location that she placed, she's from probably in the neighborhood of 100 yards away, looking toward the south end of the building. And she puts, I believe she marked in a general area south of the building, the casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So a witness from 100 yards away, placing a witness within a 10-yard distance, that would be the distinction. The other potential witness, Melanie Flores, testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well, I did a little research last evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I'd already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again,
Yes, sir. In addition, just so I can make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides that we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the appropriate.
yeah, I'm going to deny the motion for mistrial over your objection, obviously, and I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent. And I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy. But what I am going to do under Heath is I'm going to exclude her testimony.
We have just before you do that, really, I just want to know we have a response if you would consider that. So.
We would also have a response to that. And just so we can explain to the court that our primary concern with an exclusion is that basically what's happened, and I understand the jury and you'll instruct the jury to disregard. I think a lot of that testimony, though, is going to be difficult for them to disregard. A lot of it is emotional testimony. One of the things that we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that.
Okay.
And then at the conclusion of that, my thought could be to exclude it at that time.
Yes, Your Honor. It's not, because I guess my concern would be if we excluded it now and they haven't had an opportunity for.
I was going to give you that choice, but you jumped ahead of me.
Sorry, Judge. I'm sorry. I got a little afraid. I'm sorry.
All right, Ms. Mitchell, what do you have?
Your Honor, we just have a state's response to the defendant's motion to exclude the testimony of witnesses SH in anticipation of their motions. I just want to file that with the court for the court's consideration. If you could file stamp this copy too.
That's not a
Okay,
bad
And
middle
that's my copy.
ground.
The first copy is for the judge. I'm sorry.
So basically, my interpretation, at least, of this is because it's cross-examination, they will get the option to play her testimony that she gave to the Ranger, and then tell the jury, in the light of this, I will exclude her testimony. I don't know if it's enough, but it's something.
I want to file stamp copy.
Okay, so again, this is kind of a sua sponte remedy that I've devised. It's not really their motion. Did you file a written?
Did
you file something?
No.
Okay.
This is just anticipation of an oral motion to
Okay.
exclude, Your Honor.
Okay.
So, I don't know, Your Honor, can we confer as to possible remedies? And see if we can come up with a solution? Would the court be open to that?
I mean,
Oh, no.
if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters that were submitted to me. But is there a place, if you want to just go back to my office, I'll stay here and you can go back to the office that they've provided me.
We have a room actually that they've given us over here that's.
Or you can go, actually you can go to the jury room if you want to, because nobody's there. But I'm assuming that contemplates conferring that everybody goes, the state joins you. Okay. That's fine. All right, well, y'all let me know. We'll be in recess till you come back.
Okay. Now, let's get back to this while we wait. Did you hear her voice in the hearing? Oh, so soft-spoken. Oh, so... Oh. And compare that with this.
No, because I would assume that y'all knew that, given everything, given all the information that's been provided to y'all, that y'all would know that he's, the testimony, the evidence is that he's on that south end of that building shooting into room 102, right? And so if he's at 102, that's the farthest room on that end, on that south end, then somebody's gonna see him, because there's casings from that room.
But somebody is going to see him versus a person in a particular place at a particular time saw him has a lot of it's a whole different thing. And you would agree with that? That's why I was asking that question. Place and time are both important considerations when we're talking about Adrian Gonzales's conduct. What he saw, what he could see, what he could know, what others knew. Those are all important considerations.
But we already have other witnesses that say that he was,
That's other witnesses,
the
not
shooter was
this
seen at
one.
the south end of the building.
Right, and
We
you
have
would,
other witnesses.
okay, and so,
So I didn't think that would be a surprise to y'all.
well, let me ask you,
Oh, and remember what the other prosecutor said in today's hearing when the judge asked, do you have other witnesses placing him at that spot? And all he said was, there are casings, and then you have this other witness that maybe places him in between where this witness saw him and the casings. Did you hear what she said here? Let's go back and listen to what she represented to the court under oath.
those are all important considerations.
But we already have other witnesses that say that he was, that the shooter was seen at the south end of the building.
Right, and
That is what she said under oath. And the very next day, the male prosecutor makes a whole other representation. Here's a speculation, folks. Does she know that other witnesses will change the story too? And folks, this is said under oath. This is impeachment material. If this happens again in this trial, they can go back to this very moment when she, under oath, represented to the court. There are other witnesses, meaning she has prior knowledge. Today, other prosecutor represents as an officer to the court that there may be one.
We have other witnesses.
okay, and so,
So I didn't think that would be a surprise to y'all.
well, let me ask you this.
Oh, and remember what the judge says? He doesn't believe this was intentional. It was neglectful. Yeah, if this happens again, can we really say it's neglectful and not intentional?
So you say you have other witnesses that will say that. And now you have provided, you would agree, you have provided a witness that will corroborate those other witnesses, right? And make those other witnesses seem more credible instead of their testimony standing alone. Right?
Right.
Okay. And so that would be an important thing for us to know before we started this trial. And to know when you knew it. You would agree with him?
I would agree that that was already known, that was out there.
Well,
That's
I'm
why
not,
I don't understand why it's a surprise to you.
because you
Yes.
didn't report it when she told you that. That's why, because you didn't turn it over when she told you that, and it was something she had never said before. And I think you will agree with me that has not been turned over by your office in any shape or form before.
Well, I would agree with you that I so asked you to come to my office and review our file.
This was yesterday. This is the second time that she blames the defense. Well, you could have showed up at my office. No, miss. Honey buns, cupcake, donut hole. You have an obligation to turn it over. You're the prosecutor. You are the state.
I was on the record. I said, I want y'all to come look through our complete file to make sure that you have everything. And that was agreed to, but then I was never contacted. So I did make our file available on the record before trial.
And you understand the prosecutor's obligation is not on the defense. The prosecutor's obligation
Now, I
belongs
understand
solely
that,
to the
but I wanted to
prosecutor.
make sure that this is tons of evidence. I want to make sure y'all had everything, made our discovery portal available. We gave y'all a server. I wanted to make sure y'all had everything. So I did make that available.
I'll pass the minutes.
I had a few follow-up questions on timing, if I may. Ms. Mitchell, to start with, there are casings not only in front of 102, but also south of that. Is that correct?
Yes,
And those casings are not attributable to anybody other than the shooter. Is that correct?
that's right.
And both pictures and statements have been given as to that. Is that
Yes.
correct? And as far as timing, the only timing this witness has said is when she heard firecrackers, she headed to her building and saw the gun. Is that correct?
Right.
Did she say anything about Adrian Gonzales being there or not being there?
No,
Did she testify in anything about Adrian Gonzales being there or not
No.
being there? So the timing is simply, that is,
Yes, Jen the Couch Fairy. I think what the word I was looking for is bless her heart. I will add. I will try to add this one to donut hole.
she hears what she believes to be firecrackers, and where there are casings, she sees the man in black. Is that correct?
right.
And so how does that timing in any way impact Adrian Gonzales?
Speculation.
I mean, it's speculation in that sense, because she can't know our defensive strategy or what we're doing. But it's pretty clear, Judge, it's pretty clear that we have these things down to the second. Prosecution presented the things in a big blurb. We have it to the second, and the second matters, and every second matters. And so timing is important to the defense strategy. I'll just represent to the court. I don't need Ms. Mitchell to testify about
We
how important
have
it is
the
to my strategy.
timing of when every shot was fired, including the shots at the south end, Your Honor.
Okay.
We do have
Well,
examples.
let's finish up the evidence that you want. Did you have any other questions of Ms. Mitchell? Any other questions?
No, Your Honor.
Okay, did you have any other follow-up cross of Ms. Mitchell on?
I'd ask you to examine her records in camera or her notes in camera to find out if that's
Did
the
you
case.
want to call Garza or not?
Yes.
Okay, let's finish the evidence. All right. You solemnly swear the evidence in the testimony given the cause will be.
And the prosecution's investigator has been there and listened to all of this. Not saying that he's lying. I don't get the feel that he's lying, but I don't. If they have knowledge of 3 people being in that room, the 2 others should have been out the courtroom while one of them testifies.
The truth self you got.
I did.
Go ahead.
Just come up here.
Yeah, let's do it for the witness stand. You're a little far away. Okay, thank you, sir. Go ahead.
Tell us who you are.
My name is Ricardo Garza Jr.
And what do you do for a living?
I'm an investigator for the DA's office in Uvalde County.
Were you present when Stephanie Hale was interviewed?
Yes.
And do you recall her saying anything about where the shooter was?
No.
Do you recall her saying that the shooter was in black?
Yes.
And did she say anything about the white car or Adrian Gonzales during that period of time?
No.
Did she ever give any testimony about seeing Adrian Gonzales or where he was in proximity to the shooter?
No.
And did she give any indication of timing?
No.
Was she looking at a phone, a cell phone, as to timing,
No.
whether in minutes or seconds?
No.
So she could give us no clue as to what time she saw the person in black.
Correct.
That's the witness.
Investigator, so I guess first and foremost, you would be willing to get on the stand and testify that the witness, and she testified, had never said before that this person was on the south side.
I don't recall her saying that.
Well, that's different than what you testified to, which is that she did not.
Well, she did not.
Okay. So as far as the person that her telling you, you've looked through this file, I'm sure.
Yes.
Yes. And you know that it's significant when people were able to see the shooter from the time that he went in the culvert to the funeral home to walking down to the shots he was firing and who could see him and what was going on at the time. You know those are significant facts.
Correct.
Okay. And the shooter was apparently, I guess, in this December 2025 interview that you were present for, a question was asked, or Ms. Hale told you guys in that room that for the first time that anybody knows that she saw the shooter with a black shirt, wearing black, long black hair, and a black or and a long gun or a rifle. Yeah.
She said that.
Right. And you recognize that to be the first time that she has ever said that to anybody.
I don't know if that was the first time she said to anybody.
Well, I guess to anybody in your investigation that would come over in discovery to us.
Correct.
You knew that was the first time she'd ever said it.
Correct.
And nobody in that room thought to say, where did you see him?
That was not asked.
Okay. So as an investigator, as prosecutors, you have a significant fact that's come out, and you're saying there was no follow-up questions to her saying that she saw a man dressed in black with a rifle and long hair. Nobody followed up. Nobody said where. Where were you and where was he when you saw him?
That was not asked.
As an investigator, do you understand that follow-up question would be a common question that any investigator or prosecutor that you know of would ask if somebody has come up and said a material fact like that? Where were you and where was he when you saw him?
Correct.
And nobody in that room asked.
Correct.
I'll pass the witness.
No further questions.
Okay, you step down, have a seat back at council table.
May I address the court on one issue, Your Honor? Yes, sir. I'd just like to point out that the indictment says and accuses Adrian Gonzales at the time that occurred after Melody Flores informed him where the shooter was.
But that's
the
Melody
time that
Flores.
is relevant
That's not
material
this
to
witness.
case. Where the shooter was at any time before that has no bearing on Adrian Gonzales or his conduct in this case.
Well, we can't delve into their trial strategy, but I'm gleaning that there is some issue in that regard for the trial strategy. So, any other evidence on the matter?
Not from the defense, Your Honor.
Okay. Arguments?
I guess, well, the only thing that I would like to ask, because we started to speak to my client and then they put on more evidence, I had to come sit over here. I'd just like a brief moment to talk to him. I mean, it's his case. It's his part of, I want to know how he feels about, because there's certain remedies that are severe.
Well, there's several remedies, Heath, et cetera, that we can talk about, but yeah, talk to him.
Thank you, Judge.
Yeah, we are watching now, while we wait for today's hearing to continue, we are watching what happened yesterday.
You want to tell them we're another 15 minutes? If you don't mind.
Let's skip ahead to... Yeah, sadly, this is one of these cases where she was saved by incompetence. For me, yeah, I understand the difference between neglect and intent. I don't see how that matters for the defense if the prosecution fucks up because she's a moron or if she intentionally hides things. For the defense, that doesn't really matter. So I understand the distinction in law and case law, but for the defense, what's the difference? It was still hidden from them. And remember, the state is the state is the state is the state. There was one prosecutor and 2 investigators in that room. All 3 heard it. None of them asked a follow-up question. None of them passed it over to the information to the defense. None of them looked at each other and said, this should go over to the defense. Incompetence? Neglectful? Yeah. Intent might not have been there, but for Jesus, for frick's sake, for the defense, the intent doesn't matter. Never mattered. Oh, they are back. They are back. Thank you, Brooklyn. Welcome to the Viking crew.
Verify that as we speak. You're welcome to verify the clerk is sealing those documents as we speak.
Thank you.
Okay, she's ready to go.
That is a really, really good. There also comes a point where neglect becomes a tool of intent. I agree. When a prosecutor intentionally make it look like neglect by misrepresenting facts to the court, which I believe she did. Good point there. Thank you.
So once again, we're outside the presence of the jury, and I've given counsel an opportunity to confer on potential remedies in regard to the witness. So what do y'all have to report?
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
Yeah.
that part we feel comfortable.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision, depending on how that cross-examination goes, we might not ask to exclude her because there are some things that she says that we're just trying to evaluate her testimony after it is to see on balance, is it more beneficial to our case or is it not? Like, after we've unrang the bell. But if we determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to, implement that agreement.
Yes, Your Honor. What we believe is ultimately we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
All right.
Is the idea.
And I know I told her, but she knows she's supposed to be here at 9 o'clock tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that that in light of it, whatever harm that the court has determined in the defense case strategy or in emotional impact, we would add that, and we do believe that under our 403 motion and motion in limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance, because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children are, the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind that we are also going to be arguing that at a later date.
All right.
And Judge, I just wanted to be clear because I originally heard the court say, I'm willing to strike all the testimony now, but I'm also willing to entertain the defense's claim.
I want on the record, because I've denied the mistrial, that in lieu of the mistrial, I'm ready to exclude the testimony now. But if you all want to agree on this, then I will implement your agreement.
Could you give me 1 minute then? I'll make sure.
Yeah, and I guess yes, I think just the court understanding willing to strike now would the only reason we're not accepting that. What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how can you claim that the mistrial was wrongfully denied, right? So what I want to do is just say that the reason we don't believe that striking it now and like she just goes away is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
Of course,
Right.
you do.
You see what I mean? And so, what it does is it puts us in a situation where that remedy could actually harm our client worse. All right.
Well, we'll let the defense proceed as we just discussed, and she needs to be here at 9 o'clock in the morning, and then I'll make a decision on exclusion with everybody's participation after we rest or actually she's finished with redirect and recross, whatever the case may be.
Yes, sir.
But
that is the danger here, is if the defense gets the chance of cross-examining, play that entirety to unring the bell, to shovel the shit back into the horse, then it's redirect, then they will ask, depending on how it goes, Judge, we ask of you to exclude this witness testimony in its entirety. The risk here is that the judge himself will say, you chose not to. And I believe you did enough in your cross-examination that the testimony stands. Both things here can severely hurt the defense. So, yeah. Yeah, as Gigi says, how much does this magnify her testimony instead? The defense should not have been put in this position at all. And they were put in this position by neglectful incompetence from the prosecution. And they might end up losing on it, even with the remedy.
Recollection is, she's on cross now.
She is.
Okay.
We left off where I was refreshing her with her statement, and then that's when this issue came up, and so I would just continue with the cross-examination.
They've passed her and she's on cross?
Yes, Your
now.
Honor.
Okay, all right, very good. All right, so 9 o'clock tomorrow with the witness, and we will proceed at that time. Thank you very much. We'll be in recess.
All right. Yeah. Oh, I sure can pick the trials I cover. And as per usual, it turned out to be a clusterfuck. Why is it so damn hard for prosecutors to not fuck up? How can it be that I've covered on this channel over the past 3 years 25 trials, maybe more, and all but one, maybe two, we have examples of prosecutors being morons. Why? It's starting to be a pattern. It's not that this doesn't seem, I mean, the first year, sure. Second year, third year. And now all of a sudden, is this not the exceptions? Are these the normal? With prosecutors fucking up. All right, that is what I had for you today, folks. That is what I had for you. Another faster clock. 9 a.m. Texas time tomorrow. I will be here. I will cover this trial from gavel to gavel. I would not put it out of the realm of possibilities that this is not the first Brady-violation hearing. Because if they fuck up on their second witness, yeah, Amica fans, it's not new, it's just being called out now. Yeah. But all right, folks, I will see you back here tomorrow morning, 9 a.m. Texas time. That's Central time. Yeah, I'll see you tomorrow. From me and Mr. Jingles, who is somewhere around here, thank you. Thank you for allowing me to do this. Thank you for your support, for your subscribing, liking. Check my other videos, by the way. Daddy needs viewers. All right, folks. Thank you so much. See ya. Bye-bye.
Sail the raven waves, brothers, axes high, shield strong. From distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. peace.